that is the donee, does not give anything in return for the gift that is being made to him or her. And so if a donor is giving someone a gift, and I mean, this is as basic as it can go. The meaning of a gift in ordinary English language is that you don't expect the recipients of that gift to pay for it or to give you something in exchange for it, because you are doing it gratuitously. And so we say it is a voluntary transfer of property from one person who has the title to that property. That person is called the donor. And then he gifts it to the recipient, who is the donee, voluntarily, out of his own will, and without the donee giving in return for the gifts any payment. So that is what makes the gift stand out from other instruments like leases, tenancies, subleases, and then the assignment. Having given this foundation, I want us to look at leases. Again, back to our contract law. When it comes to leases, you will notice that one person has a property. He wants to give the property to another person, but the property that is given to that other person is not going to the recipients of the property forever. And at this point, I think I should clarify that we are doing land law and conveyancing. So anytime I say property, I'm referring to land. Now, if someone has a land, and we know the interest in land already, so someone who has the allodial title to land, or there is a usufructuary interest in land, or a freehold interest in land, decides that he wants to give the land to another person, but he doesn't want to sell the land outrightly. He doesn't want to give the whole of the land forever to the recipient. He wants to give the land to that other person for a limited period. And then, as he is giving the land to that other person for a limited period, he expects the other person to pay something, to pay some money, which we call rent, to him. And so the essential characteristic of a lease is that the person who is giving the land to the recipient, that person is called the lessor. The lessor has absolute title to the land. That is, he has a conveyance over the land. Either he is the allodial title owner, or that person holds the usufructuary interest. And then that person gives the land to the lessee, who is the recipient, for a limited period of time. And so we say that when it comes to a lease, it is of definite duration. The duration is definite. For instance, it can be for a period of 20 years, 50 years, 15 years, 25 years, 90 years, and so on. As long as the lessor is not giving the land to the lessee forever, but rather for a specified period of time, we create a lease. And then in return, the lessee pays rent to the lessor. Now, we come to the subset. That is a sublease. So in a sublease, we have a situation where a lease has been created. Let's say we are drawing a tree. At the very top of the tree is the allodial title owner, who has title to the land forever. The holder of the allodial title enters into a lease for 90 years. And then, in his capacity as lessor, he gives the land to the lessee for a period of 90 years. In return, the lessee pays rent to him for the whole of the period. That is the 90 years. The lessee is going to pay rent to him. Now, once the lease has been executed and registered, the lessee has the land for 90 years. The lessee is also entitled, depending on the clauses that are stated in the lease, because more often than not, there will be a covenant in the lease that the lessee cannot sublet without the consent of the lessor. So let's assume that the lessee has obtained the consent of his lessor to sublet the property. In this sublease, all that the lessee is trying to do is that he has 90 years, but out of that 90 years, he wants to give a fraction of it to a third party. The instrument that is used to do this transfer is called a sublease. It is a sublease because the lessee himself has a lease, which is for 90 years. Out of that 90 years, he wants to give the sub-lessee about 40 years. If he gives out the 40 years out of the 90 years, he still has about 50 years to himself. That is the lessee. And so when the 40-year period is over, the property will go back to the lessee, who will enjoy it for 50 years before it eventually goes back to the allodial title owner who gave it for 90 years. And so to go back, after the lease has been executed, the lessee, who now has the land for 90 years, is entitled to enter into a sublease where he gives a part of the 90-year period that he has to a third party, who will be called the sub-lessee. And in this relationship, the lessee, who had a 90-year lease and is now willing to give 40 years out of it to a sub-lessee, will be called the sub-lessor. And if that is clear, I'll move on to an assignment. Again, with the example that we had for a 90-year lease, if you have a 90-year lease, let's say the lessee has been in possession of the land for about 50 years, which means he has 40 years left before the 90 years that he was given would expire. If he decides that he wants to transfer the whole of the remaining period, that is the 40-year period that he has left, if he wants to transfer the whole of it to a third party, then the instrument to be used will be an assignment. The instrument to be used will be an assignment. It is an assignment because here, the lessee who has been given the lease has been in possession for a period of time. And then he has a certain period left. But he is willing to give all the remaining period to the third party, who will be called the assignee. When he gives the remaining period to the assignee, and the assignee remains in possession for the whole of that remaining period, when that period expires, the property will not go back to the lessee, because in this relationship, as we explained, the lessee has already given the whole of the remaining period that he has to the assignee. And when that period expires, the lessee will not come back to the equation. The property will go back to the allodial title owner. And so let's use the numbers again. So we have a lease for 90 years. The lessee has been in possession for about 50 years. And then he has 40 years left. And so he decides that he wants to transfer the land to an assignee for the whole of the 40 years that he has left. When he does this, he uses an assignment. After the 40-year period is over and the assignee has enjoyed the land for 40 years, it will go back directly to the allodial title owner and not the lessee, because the lessee has left the equation altogether. And so the main difference between a sublease and an assignment is that for a sublease, the lessee under the lease is given a part of the period that he has to the sublessee, so that when the sublessee enjoys the land for that period, then it will go back to the lessee. And so to use the numbers again, if there is a lease for 90 years and the lessee transfers the land to a sublessee for 20 years out of the 90 years, what it means is that after the sublessee has enjoyed the land for 20 years, it will go back to the lessee, who will enjoy the land for the 70 years before it will eventually go back to the allodial title owner. But in the case of an assignment, we have a situation where you have a lease for 90 years, and then let's say the lessee has been in possession for 20 years. After the 20 years, he says that he wants to transfer the whole of the 70 years left to a third party. That third party is going to take the 70 years and enjoy the land for 70 years. In this case, we say it is an assignment because the lessee is given the whole of the unexpired term that he has to the assignee. And when the assignee has enjoyed the land for the 70 years, it will not go back to the lessee because the lessee has given everything that he has to the assignee and he has left the equation. The land will go back to the allodial title owner after 70 years. So we've looked at leases, subleases, and then assignment. The next thing I want us to touch on is a tenancy. A tenancy is essentially a lease. It is also a situation where a person who has absolute title to the land is giving it to another person for a fixed period. And then in exchange, that person will pay rent. Here, we are looking at the situation, the relationship between a landlord and then a tenant. The person who is giving the land is called the landlord. The person who is receiving is called the tenant. The instances under which you will use a lease as opposed to a tenancy, for the purpose of our discussion, to simplify things, is that look at the question and then the duration that you are given. If the question tells you that the person who owns the land is willing to give the land to the person who is receiving the land for a period that is 10 years or less, then the instrument you are going to draft will be a tenancy agreement. And the relationship will be a landlord and a tenant. So we use a tenancy agreement for shorter periods, that is 10 years or less. If it's beyond 10 years, you use a lease. So to simplify everything, just use the period that you are given in the question. If the question says that the owner of the land is willing to give it to the recipient for a period of 10 years or less, you go with a tenancy agreement. If it is for more than 10 years, you go with a lease. If in the question you see that there is an allodial title owner or someone who has the usufructuary or freehold interest, and in that same question, you are told that that person has entered into a lease, giving the land to another person for a period of time, let's say for 50 years. Then the question goes ahead to tell you that the lessee who has the lease for the 50 years is willing to give only 20 years to a third party, and they have asked you to draft the appropriate instrument. Here, you know that you are going with a sublease because the question has laid the foundation for you that there is someone who is the absolute owner of the land. That person has entered into a lease for 50 years. The person who has a lease for 50 years, that is the lessee, is willing to give 20 years out of that 50 to a third party, and they've asked you to draft the appropriate instrument. Here, you know that you are going with a sublease because the lessee is willing to give only 20 years out of the 50 years to the sublessee. And after the 20-year period is over, it will revert back to the lessee who will enjoy it for 30 years. If you have a question where the question lays the foundation for you that there is an absolute owner of the land who has entered into a lease for 50 years, and this person is willing, after the person has been given the lease for 50 years, that person has been in possession for about 10 years. And that person has now entered into a contract to give the land to a third party for the whole of the unexpired period that he has. Sometimes the question will not specify the period. The question will just say that the lessee who has the land for 50 years has been in possession for 10 years. Now he has entered into a contract with a third party to give the land to the third party for the whole of the unexpired term. In this case, you know you are drafting an assignment because the lessee is going to give the whole of the unexpired term, that is 40 years, to a third party. When he does that, the lessee leaves the equation, and then it will be left with the person who will now enjoy the land for 40 years, who will be called the assignee. And then after the period of the assignment is over, the land will go back to the absolute owner of the land. So we've looked at gifts, we've touched on leases, we've touched on subleases, we've touched on assignments, and then tenancies. Now let's look at a conveyance, a deed of conveyance. Now, to explain a deed of conveyance, I'll use a lease. Remember that when we were describing a lease, I mentioned that the essential characteristic of a lease is that it is for a fixed period of time. It is for a certain or definite duration. And then it is characterized by the payment of rent by the lessee to the lessor. What differentiates a lease from a conveyance is that for a conveyance, it is not for a fixed period. A conveyance is where the person who owns the land is willing to sell it outrightly to the recipient. And so you sell the land forever. And so this is not a case where we are looking at 90 years, 50 years, whatsoever. The person who owns the land is selling the land to the recipients forever. And so in a conveyance, the consideration that is given is not payment of rent. The recipients in a conveyance is going to pay a lump sum as the consideration. So he's going to pay a certain amount of money to the donor, the owner of the land, for the fixed for the land that is given to him forever. But if it had been a lease, then the land would have been given to the lessee for a period of time, a fixed period, either 20 years, 50 years, 90 years, or whatever period as the case may be. But when it's a conveyance, the land is given to the recipient forever. And then in exchange for that, he pays money to the owner of the land. And that is the consideration that is given. Now, as I explained from the beginning, most of these instruments have at the core the basic principles of contract law. And so if someone is going to sell his or her land to you forever and you are going to pay money for it, then the basis of your arrangement is a contract. And to ensure security of title, it is prudent for you to enter into a contract for the sale of land with the owner of the land, such that after you enter into this contract, that is going to be the instrument on which you are going to base to demand specific performance from the owner of the land if subsequently he refuses to transfer the land to you. And so you have entered into a contract with someone who owns the land for that person to sell his or her land to you. The instruments that the person is going to use, which will pass title from him to you, is going to be the deed of conveyance. But before he executes this deed of conveyance to you, the negotiations between the two of you, which will lead to the conveyance, that negotiation will lead to a contract between the two of you. More often than not, the transactions that happen in this country are done orally. And so someone will come and approach you, I want to buy your land. Then you have conversation over a period of time, negotiating, for instance, the price, the period of time in which you are supposed to conclude the negotiations, and then if he's going to pay the land if he's going to pay for modalities, the payment, whether it's going to be by check, whether it's going to be by cash. All of these things are terms of a contract. And this contract is for the sale of the land to you. But as I mentioned earlier, the instrument that is going to use to transfer the land to you will be the deed of conveyance. Yes.
Senior, please, sorry to cut you, but it looks like someone has had their hand up for a while. I don't know if the person has been able to speak.
Thank you. Thank you for drawing my attention. I think it's Abna. Yeah, Abna, can we hear your question?
Thank you for the opportunity. You spoke about tenancy. Did you say when the agreement is less than 10 years, then a tenancy agreement is supposed to be drafted as opposed to a sublease?
Yes, as opposed to a lease and not a sublease. So when you look at the past questions, if the foundation or the basis that the question is giving you goes like this. First, if the question identifies someone as being the owner of the land, the absolute owner of the land, and then the question goes ahead to tell you that the person who is the absolute owner of the land has entered into an agreement to transfer the land to someone who is the recipient. And the question goes ahead to say that the period in which the parties have agreed to transfer the land is for 10 years, right? If it's 10 years or less, then it's going to be a tenancy agreement you will draft. And the relationship between them will be landlord and tenant. And the additional point to note is that in most of these, in this type of question, you'll notice that the property, the land, usually is in reference to residential property. So it's usually going to be a building, whatever that is used for. So it's going to be a building, whether the person is going to stay there for residential purposes or whatsoever. It's for 10 years or less. Then you draft the tenancy. On the other hand, if the question lays the foundation for you that there is an absolute owner of the land, this owner of the land has entered into an agreement to transfer the land to another person who is the recipient, and the period that you are given is more than 10 years. So let's say you have 15 years, 20 years, 30 years, 45 years, 50 years, 90 years. For that, you are going to draft a lease. And so we use the tenancy for shorter periods and then the lease for longer periods. And then in the questions that you will be answering, when you look through the past questions, it's either 10 years or less or more than 10 years. If it's 10 years or less, you go with a tenancy agreement. If it's more than 10 years, you go with a lease. For the sublease, you only draft the sublease if the question lays a foundation for you that goes like this. First, the question tells you that there is someone who is the absolute owner of the land. That person entered into a lease with LSE for a period of time. So let's say 50 years. Then the question goes ahead to tell you that the person who has the lease for 50 years has decided to grant a portion of that period, to grant the land to another person for a portion of that 50 years. So let's say if he decides to give to the third party 10 years, 20 years, 15 years, 30 years, or even 40 years, as long as he is giving a portion of his 50 years to that person, such that when that person enjoys the land for that period, whether 10 years, 15 or 20, the land will come back to him. Then you are going to draft a sublease, because a sublease arises out of a lease. And so before you can have a sublease, there must be in existence a lease. And then the lessee under the lease now decides to grant a portion of that term to a third party who will be the sub-lessee. Abna, can I know whether your question is answered?
And am I still? Please, I'm okay. Thank you.
Thank you. Emmanuel.
Yes, yeah. Thank you so much. Please, I want to know the difference between an assignment and a lease. I was a bit confused at that point. So you can let me know the distinction, please. Thank you.
Okay. So an assignment and a lease. So first, the lease, as I was explaining, arises where the person who owns the land, the absolute owner of the land, whether the person has allodial title or freehold interest, decides to give the land to a lessee for a specified period in exchange for the payment of rent. And so let's say he has decided to enter into a lease for 50 years. Relationship that you
Hello.
hello. Yeah, sorry, I got a call. I think I'm back on. So as I was saying, the relationship that you have will be that of a lease between the lessor and the lessee for a period that is 50 years. The person who grants the lease, that is the lessor, is the person who has the title to the land, the absolute title to the land, whether he is an allodial title holder or he has the freehold interest. And so he will be the lessor, and then he gives the land to the lessee for a certain period, 50 years, 90 years, as the case may be. Now, when it comes to an assignment, the assignment arises out of a lease. And so before there is an assignment, there is first the assumption that there is a lease in existence. And so in the example that we just gave, someone has a lease of the land for 50 years. And that person has been in possession and enjoyed the land for 10 years, right? Which means he has 40 years left before his lease will expire. Then he decides that he is going to transfer the land to a third party for the whole of the 40 years that is remaining. If he does this, we say that he is assigning the whole of the unexpired term that he has in the lease to this third party. And the instruments that he is going to use will be the assignment. So he is assigning the remaining portion of his interest, that is the 40 years, the whole of it, to the third party. When you do an assignment, you will notice that the person who had the lease for 50 years, who has used 10 years out of it and is willing to give the whole of the 40 years out, that person, after he assigns his interest, is going to leave the equation altogether. We will not see him again, which means that he needs some consideration to do that. And so as the assigner, the assignee is going to pay him some money, which is a lump sum, right? And then he will take that lump sum and then assign the whole of his interest to the assignee. The assignee now will come and step into his shoes and take the land for 40 years. But you remember that we said that for the allodial title owner, he has given his land out for 50 years. And in exchange for that, he expects someone to pay rent to him. The person that he expects to pay the rent to him is the lessee to whom he gave the 50 years. Now, this lessee has used the land for 10 years, and then he has assigned the rest, the remaining 40 years, he has assigned it to an assignee for 40 years. He takes money from the assignee and then leaves the equation. But the rent has to be paid. And so once the lessee leaves the equation and then the assignee steps into his shoes, the assignee will now assume the responsibility of paying the rent. So to answer your question again, the difference between a lease and an assignment is that for a lease, it is the absolute owner of the land, whether the allodial title holder or the freehold, the person who holds the freehold interest is going to give the land to the lessee for a fixed period, and in exchange, there will be payment of rent. When it comes to the assignment, there is already a lease in existence, and then the lessee has used the land for a period of time, and then he has some period left that has not expired. Then he decides that he's giving the whole of the unexpired term to the third party who will become the assignee. Emmanuel, let me know if you need further clarification on this.
Okay, so I'm okay. I'm very okay.
All right.
Thank you
All
so
right.
much.
There's another hand. Gladstone. I hope I got your name right. Can you ask the questions? Okay. In the absence of no question, I think we can proceed. So I was talking about the contract for the sale of land before we paused to answer some questions. So when it comes to a contract for the sale of land, as I was explaining, if you enter into an agreement for somebody to sell his land to you, that agreement is a contract. But it is not that agreement that is going to pass title to the land to you. It is an instrument that is able or capable of passing an interest in land to you that must be used. And that instrument is the deed of conveyance. But before the deed of conveyance is executed, both parties would have entered into some negotiations regarding, for instance, the purchase price, the mode of payment, and other important terms of that agreement. And so that agreement that you enter into after the negotiations is a contract. And when you put that agreement into writing, you say that you have entered into a contract for the sale of land. So that subsequently, if the person decides to not transfer the land to you, if the person decides to not execute the deed of conveyance for you, you can go to court and sue him based on this contract that you have entered into for the sale of the land. And if you are able to show, for instance, that you have paid the purchase price or that you have done something to show past performance of the contract, then you can demand specific performance of this contract that you have entered into for the sale of the land. And so you enter into a contract for the sale of land before you execute the deed of conveyance. That is going to be the instrument that will transfer title in the land to you. The next thing I want us to touch on briefly is a trust. And so when it comes to trusts, you have the relationship between three people. You have the settlor, you have the trustee, and then the beneficiary. And so a trust arises in a situation where, and again, I have to say that anytime I say property, I'm referring to land because we are doing land law and conveyancing. So you have a situation where someone owns a land. that person wants to transfer the land to another person, but for some reason he is unable to do that directly, and so he transfers the land to someone who will be an intermediary to hold the land as a caretaker on behalf of the person who is the ultimate beneficiary. In this relationship, the person who owns the land is the settlor. The person to whom the land is given as the intermediary or the caretaker is the trustee. And this trustee is holding the land in trust for and on behalf of the person who is the ultimate beneficiary of the land. And so that is the relationship between the settlor, the trustee, and then the beneficiary. And you would usually find that the trust relationship arises in a situation where the ultimate beneficiary is a minor. And because at common law, a minor could not hold land, because of the lack of capacity of the minor to hold the land, the owner of the land, so let's say a parent has land, he wants to transfer it to his child. The child is about 10 years. At common law, the child does not have the capacity to hold land. And so what would happen is that the owner of the land, who will be the settlor, will enter into a trust, will execute a deed of trust. And this deed of trust is going to transfer the legal title to the land to someone who is going to be the trustee. This person would have the capacity to hold land. And so it could be anyone who has attained the age of majority and is capable of holding land. Then this person who is the trustee is going to hold the land in trust for and for the benefits of the child. Now, in equity, we say that the legal title to the land is vested in the trustee. However, the equitable title to the land, that is the beneficial ownership of the land, vests in the beneficiary. And so the beneficiary has an equitable title, but it does not have the legal title. And all of this arises from the very old distinction between common law and equity. Because at common law, if you have not attained the age of majority, you cannot hold title to land. And if you cannot hold title to the land, then what the settlor will do is to transfer title to the land to someone who is capable of holding land, who has the capacity to hold land. And for that, common law would accept that because it meets all the essential requirements to create a valid contract because there is capacity. However, equity wants to ensure that the person to whom the land has been given as the trustee does not abuse his or her powers. So that person does not take the land absolutely. That is why equity has created that trust relationship, so that the trustee, although has the legal title, the equitable title in the land is vested in the beneficiary. And so everything that the trustee is going to do in relation to the land must be ultimately to the benefit of the beneficiary. And in theory, there are certain fiduciary duties that the trustee owes to the beneficiary. And so if you have a question where someone owns land, that person is willing to transfer the land to a minor, but because of the lack of capacity on the part of the minor to hold the land, the person decides to transfer the land to some person who will be the intermediary. Then you know that the instruments that you must draft will be a deed of trust or a trust instrument. But we can have a situation where there is no minor in the scenario at all. You have persons, all of whom are of they have attained the age of majority. They can hold property, but they want to appoint some of them to hold the property and to manage it as trustees on behalf of the rest of them. In that instance as well, you are going to draft a trust instrument. And so, for instance, when you look at the past questions, you'll notice that there is this particular scenario that they usually bring, where a group of people are entitled to property. So they are joint owners of property. So let's say there are 5 of them. Then about 3 of them are outside the country, they stay abroad. Then they decide to appoint the 2 who are in the country to manage the property on behalf of the 5 of them. And then they can give them the power as trustees to even sell the property and then to use the proceeds for specific things that they will all agree on. When you have this example, this scenario in a question, you know that you are going to draft a deed of trust and it will be a trust for sale, because you have a situation where persons who are entitled to property are giving the power to some of them to be their trustees. And then they are further given the power to even sell the property and use the proceeds for specific things. And so in this situation, the settlors are going to be the 5 of them. Then the trustees will be the 2 who will be given the power to manage the property. And then you'll notice that it is for the benefit of all the joint owners of the property. And so they are all beneficiaries in that sense. Another example of trust that you may have is a situation where someone who owns the property, the settlor, has given the property to a minor again. This time, the settlor says in his will that he's giving the property to a minor. And then he says that until the minor comes of age, he wants to appoint certain people who are his executors in the will to hold the property on behalf of the minor until the minor attains the age of majority. In this case, at the time that the people will become aware of this testamentary disposition, the settlor who made the will would have died. And then it is after he dies and they've gone to prove his will, the will has been admitted to probate, we know exactly what his wishes are. It is at this point that it will become clear that he willed the property to the minor. and then he wished that the executors should hold the property for the minor until he attains the age of majority. When you have a question like this, you are also going to draft another trust instrument. This type of trust is called the declaration of trust. The declaration of trust, we call it a declaration of trust because you notice that the settlor who made the will would have died. And so he is not alive to come and draft a trust instrument where he or she is going to sign as the settlor. But you have his executors who have the power to manage his affairs. And these same executors have been appointed as the trustees. And so what the executors are going to do is that they will prepare an instrument. In this instrument, they are going to narrate the facts that have led to the transfer. So first, they are going to tell us that the settlor, the person who has died, he owned the property. He owned the property by some conveyance that he acquired. Then, whilst he was alive, he made a will. In that will, he gave the property to a minor. Then he died on a particular day. After he died, in his will, he appointed the executors named so and so to be his executors. Then, after he died, the executors went to court and then proved the will. The will was admitted to probate. The executors who were appointed in the will as trustees, in their capacity as executors, are declaring themselves as trustees of the property for and on behalf of the minor until the minor attains the age of majority. And so this is also a trust instrument called the declaration of trust, where the executors, or even in the case of intestacy, the administrators would declare themselves as trustees of the property for and on behalf of the minor who is the beneficiary until such time as the minor attains the age of majority. And so that is for the trusts. The other instruments that you would be asked to draft are wills, power of attorney, statutory declaration. I think at this point, everyone has done equity and succession, and so we know what a will is. A will is a testamentary document by which a person called the testator disposes of his or her assets and then provides for things that he wishes to take effect upon his or her death, appoints his executors, and then the will is witnessed by at least two persons. The formalities of a will must comply with the Wills Act, where the person who is executing the will is an illiterate or a blind person. You must bring your jurats, and it must be witnessed by at least two persons. And it's very important because in an exam, if you draft a will and you forget to bring these two witnesses, or if you bring only one witness, depending on the discretion of the examiner or what is in the marking scheme, your whole drafting can be cancelled. You get zero because you didn't bring two witnesses and you brought just one. When we eventually get to discuss wills, we'll go into details on that. But let me touch briefly on power of attorney and the statutory declaration. A power of attorney is used where someone who is called the principal appoints a third appoints someone who is called the attorney to do certain things that he, the principal, has the power to do legally. So anything that you can do legally, you can appoint someone to do that on your behalf. For instance, if you are traveling outside the country and you have a court case pending in Takrady and you cannot attend courts, but you want to send someone, either your personal assistant or your sibling or your parent or your colleague, to go and represent you in court. What you need to do is to execute a power of attorney. And in this power of attorney, you are giving the person the authority to represent you as plaintiff in that action against whoever the defendant is. And it is very important because if you are suing someone outside the country and you want someone to represent you in the action here in Ghana, you must execute the power of attorney for them so that they represent you. And without the power of attorney, the person will lack the capacity to sue in your name. And so one of the things that you will notice on the endorsement on the rates is that the person who is abroad will be named as plaintiff, all right, but the rate will also state that you are suing by your true and lawful attorney. Then the name of the person to whom you've executed in whose favor you've executed the power of attorney will appear. A power of attorney is one of the simple instruments to draft. It can be as short as half a page or even just a page. And it has primarily three main parts. And so when we get there, we will discuss that. But essentially, it begins with the part where after the CPD or the commencement date parties, CDP, you have, so I also have to mention that it is one of the instruments that is drawn unilaterally, such that it is only the principal who executes the power of attorney. The attorney does not also sign. And so when you get to the commencement dates and parties, it is the party will be only one at that side. It will only be the principal. And then you proceed to state exactly what you want your attorney to do for you. And so you have the clause where you appoint the person to be your attorney, and then you specify exactly what you want them to do for you. Then there is the part where you declare that you are going to indemnify them for everything that they do in your name and any expenses that they may incur. You are going to reimburse them. Then you have the last part where you state that the power of attorney is going to be governed by the laws of Ghana. And then essentially you are done. It is executed by you, and it is witnessed by at least one witness. When we get to discuss power of attorney, we will look at some case law as to who can be a witness in a power of attorney. A power of attorney has to be stamped either by a commissioner for oath or a notary public. If it is done outside the country, then a notary public. If it's done within the country, you can go for commissioner for oath or power of attorney. Previously, there were some decided cases that held that if you have the commissioner for oath stamping your power of attorney, and then you do not have any other person being your witness, then the power of attorney cannot be enforced. However, in recent times, the Supreme Court has reversed that decision to hold that they are going to apply the purposive approach to interpretation to make sure that when we talk about witnesses, we just need to ensure that there is someone who is able to attest to the fact that the attorney duly executed the power of attorney. And so if you have a commissioner for oath, that commissioner for oath can also double as a witness. So when we get to discuss the power of attorney, we are going to look at all of that. The last instrument that I want us to look at is the statutory declaration. A statutory declaration is basically an instrument that is used if you want to put out certain facts that you think people should be aware of. So you want to make declaration in respect of certain facts. And it's usually in relation to land law and conveyancing. It's usually used in a situation where someone wants to declare that they still retain ownership to land. So to go back a bit, you remember that we talked about instruments that are used to transfer land or interest in land. For instance, we talked about the deed of conveyance. And then we talked about leases, we talked about assignments, we talked about subleases. And then whenever we spoke of these instruments, we noted that there is someone who has title to the land or someone who has an interest in the land. And it is that title you have in the land or that interest you have in the land that gives you the capacity to transfer the land to another person or to transfer interest in land to another person. And it is that interest that you have in the land that gives you the capacity to enter into a contract for the sale of the land. And that capacity you have is always evidenced by some instruments. So it's either you have a deed of conveyance or you have a lease, you have a sublease or an assignment. But something can happen such that you will lose your copy of the lease that you have. And so if there is a flood in your area and then you lose your indenture, your lease or your conveyance, but you still own the land and you want to transfer it to somebody. As part of due diligence, the person you are selling the land to is going to ask you to produce or provide the conveyance that you have, something to show that you are the true owner of the land. But this is a situation where there was some fire outbreak or there was flooding or something happened and you've just lost your documents or thieves broke into your house and they've stolen your title documents. So what you can do is that you are going to make a statutory declaration. And in that statutory declaration, you are going to narrate the facts that first you are the owner of land situated at so and so. So you describe the land. Then you tell us that you had a lease, execute a lease evidencing your title to the land, or that you had a conveyance evidencing your title to the land. Then you narrate the fact that on this day, there was heavy rainfall, which resulted in flooding. And for that reason, you lost your title documents. But you want to reaffirm or that you still want to declare that you are the owner of the land. And for which reason you are making this statutory declaration. Sometimes when you are going for a loan from a bank and you don't have title documents, they will require you to go and do a statutory declaration. And so you also narrate that in the facts that you have approached this bank for a loan, and since you have lost your title documents, you are making this statutory declaration to to just reaffirm the fact that you still own the land. So that's for statutory declaration. When we get to the drafting aspects, we will discuss the formalities for drafting the statutory declaration. Okay, I think it's left with one last instrument I haven't mentioned, and that is the vesting assent. The vesting assent is used in the case of wills and then intestacy. So, in a will, a testator makes a testamentary disposition of land to a beneficiary under the will. Then the testator dies and the executors have gone to court to prove the will. The will has been admitted to probate. After that, the executors have two main duties. First, they are to pay all the just debts of the testator. So any person that the testator owes as a creditor will come forward, make a claim, and then the executors will pay the debt that is owed. After all the just debts of the testator have been paid, the next thing that the executors are supposed to do is to distribute the estates of the testator, the deceased person, according to the wishes of the will which has been admitted to probate. And so in the will, since the testator gave the land to a beneficiary, the executors have to give the land to the beneficiary. And the instruments that the executors must use to transfer that land to the beneficiary is what we call the vesting assent. And this is provided for in the Administration of Estates Act, Section 96. It states clearly that the executors of the will must execute a vesting assent before the land can be transferred to the beneficiary. And it is the executors who execute the vesting assent because, as you know from your equity and succession, that upon the death of the testator, his property, all of his property, become vested in the executors. And by the power given to the executors, the probate that the court has given to the executors, they have title to the property in the meantime. And so the instruments that they must use to transfer the property to the beneficiary will be the vesting assent. Without the vesting assent, a beneficiary cannot deal with the property as his own. And so if you are a beneficiary under a will, despite the fact that the testator has given you the property in his will, you cannot go ahead and exercise acts of ownership over the property. You must wait for the executors to execute the vesting assent for you. And after the vesting assent has been executed for you and it has been registered, it is then that title to the property becomes vested in you, the beneficiary. In the same way, if the person died without making a will, that is in the case of intestacy, and the administrators of the estate have been appointed and the court has given them letters of administration, their duties in administering the estate of the deceased person, again, first is to pay all the just debts that were owed to the creditors of the intestate. After that, they are supposed to distribute the estates of the deceased person according to the provisions of PNDC Law 111. And if you are someone who is entitled to land under the Interstate Succession Act, then the administrators of the estates have to execute a vesting assent to transfer the title to the land to you. it is only after the vesting assent has been executed that the beneficiary, whether under intestacy or under a will, can enjoy the property. And so when we come to discuss vesting assent later, we will look at cases where the beneficiary under a will, or in the case of intestacy, has not been given the vesting assent, and then they've gone to court to sue someone over the land, where the beneficiary who doesn't have a vesting assent is asking the court for an order to declare title to the land in themselves. When you go to court without a vesting assent as a beneficiary, naturally, what will happen is that the defendant will raise an objection as to your capacity to sue, because it is only someone who has title to the land that can bring an action in relation to the land to ask for declaration of title. And without a vesting assent that gives you the title to the land, you do not have the capacity to sue in relation to the land, despite the fact that in the will you have been given the property, or that under PNDC law you're entitled to the property. But there is some case law that has given exceptions to circumstances under which a beneficiary can actually go to court and sue in respect of the property, even though he or she does not have a vesting assent. And so when we come to discuss vesting assent, we will look at this case law. Are there any questions before we move on to discuss gifts? Yes, Abna again.
All right. So I'm beginning the class. You said there are 14 instruments, but I only gleaned 12 from what you said.
I don't know, maybe I got the number wrong, but can we quickly go through the instruments we've discussed so far? Abuna, can you do this with me?
Okay.
So
okay.
We've done gifts.
Okay.
We've done trusts, right? In
Yes.
discussing trust, I think we discussed the deed of trust, the declaration of trusts, and then the trust for sale. We've discussed.
Hold on. Deed of trust is different from the trust itself.
No. So let's use trust for sale, right?
Mm-hmm.
Let's use trust for sale as one thing, trust for sale, and then deed of trust, where you have a settlor beneficiary trustee relationship. And then let's use declaration of trust as another instrument.
Yeah.
Mm-hmm. And then we have, I think we talked about contract for the sale of land. We talked about conveyance. We talked about lease, sublease, tenancy, assignment, statutory declaration, wills, vesting assent, power of attorney. What do we have for that? Is that 13 or 12?
13.
13. I think the last thing we didn't mention is a mortgage.
Okay.
Yeah. So for mortgages, a mortgage is basically an instrument that you draft for to evidence a collateral for a loan that is given to you. And so the mortgagor is the person who owns the land, and then he executes the deed of mortgage on behalf of a mortgagee. The mortgagee, and usually this happens in the relationship of banks and then their clients or customers. If you approach a bank for a loan and then they ask you to give a collateral or a security for the due repayment of the loan that they are giving you, you'll be required to execute a deed of mortgage for the benefit of the bank. And so you own a land, then as the mortgagor, you enter into a deed of mortgage on behalf of the mortgagee, where you say that you are using your land as collateral for the loan that has been given to you. And the land that is given is a security. It's a security because we want the bank is protecting itself from a situation where they give you the loan and then you run away without paying. And so to secure the facility, secure the repayment of the facility that has been given to you, the bank would require this mortgage. And so in the mortgage, some of the things that you will see is that there is going to be a clause that will talk about the fact that you have received some money, which is the consideration for which you are doing the mortgage. You have received some money from the mortgagee, and you have confirmed, you acknowledge receipt of that money, and then you also say that you are going to pay the money together with any interest that will accrue on it. And then usually you have a payment plan as part of the schedule in the mortgage. And then you go to your operative part where you talk about the fact that you own the land, and as the beneficial owner of the land, you are mortgaging it to the mortgagee to secure the repayment of the loan amount, which is the principal amount, together with any interest and then any other money that you have covenanted to pay. And then usually some of the clauses that you see in a mortgage are insurance. You know, you are giving out property as security for the loan. And so if something happens and the property is lost, for instance, if there's a fire outbreak and then the property is burnt to ashes, then it's a loss. It's a loss to the bank because they have nothing to secure the loan. And so one of the clauses that you will see in a mortgage has to do with an insurance. So you are going to covenant that you are going to insure the property, or that you have insured the property with a reputable insurance company, such that if there is anything that happens that makes you lose the property, there is that insurance cover that the bank can fall on. And then ordinarily, under the Conveyancing Act, since the mortgage is not a conveyance, since you are not selling the property but only using it as a security, you can deal with the property, right? And then you do not need the consent. Ordinarily, you do not need the consent of the mortgagee to transfer your property, even though you have used it as a security. And the reason is simple. I have come for a loan from a bank. Let's say I've come for 100,000 cedis from a bank, and then I've used my property at Accra as the collateral. I've executed a deed of mortgage. Under the Conveyancing Act, I don't need the consent of the bank if I want to transfer this property I have in Accra, even though I have not fully repaid the loan that I took together with the interest. And the simple reason is that it is a mortgage. It's only used as a security. It is not a transfer. So if I transfer my interest in the land to a third party, what it means is that the third party takes the land with the burden of the mortgage. And so whoever assumes title to the land should know that there is a mortgage on the land. And if I fail to repay, the bank can come in. However, the Conveyancing Act also says that the parties are free to agree that a transfer of the land by the mortgagor must be with the consent of the mortgagee. And so if the parties agree in their negotiations, then you can include it in the deed of mortgage that the mortgagor cannot transfer the land except with the written consent of the mortgagee. And then you say that this is so despite the provision in the Conveyancing Act, because you are expressly contracting out of that provision, simply because the provision gives the parties the option to contract out of it. The other thing that stands out in a mortgage that I think we should mention at this stage is that when you have duly repaid the loan and the interest and any amounts that you have covenanted to pay, the bank is supposed to discharge you. So the mortgage will be discharged. And then the bank would have to execute a deed of discharge in your favor, showing that you no longer owe them and that the mortgage is no longer in force. And so there is also a clause that says that once you fully repay the loan, together with the interest and any amount that you have covenanted to pay, the bank will execute a deed of discharge in your favor. And just as you went to register the deed of mortgage, the deed of discharge must also be registered with the Lands Commission. And all of this is important because when you want to sell your land to someone, the person is going to do their due diligence. As part of due diligence, they are going to write to Lands Commission to conduct a search on the land, to tell them who owns the land, and if there are any charges over the land. And a mortgage is a charge. And so if you entered into a mortgage, Lands Commission is going to reply the person that there is a deed of mortgage registered with us in favor of, let's say, Absa Bank in relation to this land. The mortgage is dated on this day. And then if you have fully paid the loan together with the interest and any amount that you covenanted to pay, you have to insist that the bank executes the deed of discharge for you. That is why we have this clause in the mortgage. So that when Lands Commission is replying the person who is doing the due diligence, after stating that there was a deed of mortgage, Lands Commission will add that there is also a deed of discharge, discharging this mortgage, such that the land will now be free from all encumbrances. So I think that would be it for mortgage. And that brings us to 14 instruments that we've looked at briefly. Alhaji, you can ask your question.
Hello. Good morning. Thank you so much. I think in the discussion, my question has been answered, so I'm good now. Thank you.
All right, you're welcome. Okay, it's 11:37. We have a few minutes. So I want us to briefly go through gifts. So, yes, please. I'm listening.
One quick question.
Emmanuel.
Is it mandatory that the name of the instrument, the name on the property is changed into a both names, like of the mortgage and mortgagor? Is it mandatory?
No.
It's not mandatory, right?
No, because and it's very important you ask this because a mortgage is not a transfer of title. You are not transferring your title to the land. You still own the title to the land. You are only using it as a security. And so when you go to Lands Commission will register the mortgage, but it will not change ownership to the land at all. It is after you default in paying the loan, then under Section 18 of the Mortgages Act, there is a procedure that the mortgagee, that is the bank, must follow if they want to enforce the mortgage. They must serve demand notices on you and all of that. And then the law says that they must go to court to seek an order for the sale of the property. And so they would go to court, and then they will serve notice for you to come and show us. They serve notice on you to come and show us as to why the property should not be sold in, and then the proceeds be used to satisfy the debt that you owe them. And if you fail to give any just cause, and the court gives an, will use the names of the parties on the title documents with land commission will not change, because the ownership of the land does not change. The property will only be used as a security.
Very well. Thank you, sir.
You're welcome. Alaji, do you still have a question? I see your hand up. Okay. I think there is no question. So let's briefly, we have 20 minutes. Let's briefly look at gifts. So when we began the discussion, I mentioned that a gift is a voluntary transfer of property from one person who is the donor to another person who is the donee. And then I was using the basic principles of contract law to explain that when it comes to gifts, one thing that distinguishes it from leases, conveyancing, subleases, assignments, and tenancies is that the person who is receiving the gifts does not pay money for it. The person does not give valuable consideration for it, because it is literally a gift. It is given gratuitously without you paying anything for it. And so the requirements for making a gift basically is that someone owns property. The person intends to gift it. Then the person actually gifts the property to you. So he delivers the property to you. We are doing land law and conveyancing. And so again, when I say property, we are talking about land. We are not talking about any other thing. Other things can be gifted. You can gift movable properties. You can gift cars. You can gift chocolates. You can gift phones, everything. But we are talking about land. So the owner of the land has title to it. Then he expresses his clear intention that he wants to gift the land to you, right? Then the next thing he has to do is to actually give the property to you. How does he do it? He must deliver the property to you by giving possession to you. So in the case of a land, he must execute some instruments which shows that he's giving the land to you. And then he must divest himself of physical possession so that you will come and take possession. And then when you take possession of the land, we say that you have accepted the gift that has been given to you. And so when all of these requirements are there, we say that you have created a perfect gift. So a perfect gift must have 4 elements. The owner, who is the donor, must be the owner of the property. And so you must have title to the property. The second thing is that you must show your intention that you want to gift the property, right? Then the next thing is that you must deliver the property to the beneficiary, who is the donee. And then the donee lastly must accept it. When all these elements are there, you have created a perfect gift. If any of these elements, and before I go forward, I have to mention that a gift is given during your lifetime. During your lifetime. And so if you give the property in your will, it is not a gift. The gift we are talking about is one that you give during your lifetime. And then we are saying that if the donor wants to make a gift, but then the gift falls short, what he's trying to do falls short of these four essentials, then we would have a situation where it will be an imperfect gift. And so we have perfect and imperfect gifts. A perfect gift has all the four elements. An imperfect gift arises where you have title to the land, all right, but then the essential elements, the essential elements that you need to create a perfect gift are missing. In that situation, you have an imperfect gift. Even though an imperfect gift has been created by reason of the absence of the elements that you need to create a perfect gift. In equity, there are three instances under which equity can perfect an imperfect gift. And so we can make an imperfect gift to become perfect so that the donee can take the benefit of the gift. And then we have three main instances. We have first the rule in strong and bad. Then we have the doctrine of donatio mortis causa. Then lastly, we have proprietary estoppel. So I'll take them from the last to the first. So proprietary estoppel is the simplest of them all. We all know the equitable principle of estoppel, which is that if you have made a representation to someone, based on that representation, the person has relied on that representation to alter his or her position to his detriment, then equity would say that you are stopped from changing your position. So you make a representation to someone that you are giving them a gift. Based on that representation, the person takes certain steps in reliance on that representation that they are receiving the gifts. Then you decide to back out all of a sudden. Equity is saying that we cannot allow you to back out of that arrangement belatedly. You will be stopped. And so the person, the donor, can say that you will be stopped from using the imperfection of that gift as an excuse to not execute a deed of gift for them. And so proprietary estoppel basically arises in a situation where there is an imperfect gift. However, the intention to gift was so clear that the donee has relied on that to alter his position. Then the donor is trying to use the fact that the gift is imperfect as an excuse to back out of that relationship. Then equity is saying that you will be stopped from doing that. And so proprietary estoppel is one of the situations where equity is going to perfect an imperfect gift so that the donee can take the benefit of the gift. Now, this second thing is the rule in strong and bad. The rule in strong and bad, as the name suggests, arises from the case of strong v bad, strong versus bad. So the rule basically is that if the donor has made his or her intention to gift a property to the donee during his or her lifetime, then that intention clearly persists throughout, even up to the point of his death. But he was not able to execute a deed of gift such that there is no perfect gift here. However, when the donor died, he made a will. And in his will, he appointed as his executor the person who is the donee of that imperfect gift. Or he died intestate, and after he died intestate, the person who is the donee of that imperfect gift has been appointed by the court as the administrator of the estate of the deceased donor. Then equity is saying that by reason of the appointment of the donee as the executor of the will of the donor, or as the administrator of the estate of the donor, the imperfect gifts will be perfected. And the case of Strong and Bird gives the classic example of a situation where equity will perfect an imperfect gift, where the donor had a clear intention to gift, but died without making the gift. But the donee has been appointed as an executor of the estates of the donor. And so in Strong and Bird, the defendant, Bird, he was living in a house with his stepmother. He owns the property, and so the stepmother pays rent to him. Then he went to borrow money from his stepmother. The stepmother gave the money to him. Then they made an agreement that instead of Mr. Bird paying the amount that he borrowed to his stepmother, they are going to make an arrangement where the rent that the stepmother is supposed to pay will be reduced. So if let's use an example. Let's say the stepmother has to pay a monthly rent of 100 cedis, but Mr. Bird went to borrow 1,000 cedis from the stepmother. Then they enter into an arrangement that instead of paying the 1,000 cedis to the stepmother outrightly, the stepmother is going to pay 90 cedis rent every month, such that the 10 cedis that has been taken off will be deducted from the debt that you owe the stepmother. And so she's going to pay 90 cedis rent until the 10 cedis that has been taken off is able to accumulate to reach 1,000 cedis. So this was the arrangement. Then the stepmother paid the reduced rent only 2 times. After that, she went back to paying the full rent, 100 cedis. She went back to paying the full rent, 100 cedis. Although the total debt that was owed to her by Mr. Bird had not been fully repaid. She decided to only pay the reduced rent 2 times, and then she went back to paying the full rent. Then, during her lifetime, she never asked him to pay the debts that Mr. Bird owed her. And then she died. After she died, it was discovered that Mr. Bird had been appointed as the executor under her will. So The plaintiff, who described himself as the next of kin of the stepmother, then went to court to say that Mr. Bird borrowed money from the stepmother while she was alive, and he has not fully repaid it. And so he should come and repay the money. So Mr. Bird has been sued as a defendant. Now, at common law, the common law position is that the mere fact that you owe me and I have kept quiet and I've not asked you to come and pay my money, and the mere fact that I was paying a reduced rent did not discharge you of your liability regarding the debt that you owe me. If you owe me and I've kept quiet, it doesn't mean that you still don't owe me. That is the position at common law. But in equity, equity is saying that, first, let us look at the role that an executor plays in administering the estate of a deceased person. First, as I was explaining earlier when we were talking about the vesting assent, I said that the duty of the executor or the administrator is to first pay all the just debts owed by the deceased person. And so in the case of the in the case of a will, for instance, in this case we are looking at, it is the duty of Mr. Bird as the executor to pay all the just debts that are that's the testator, the stepmother, owed to the creditors. At the same time, it is the duty of the executor to collect in all the debts that is owed to the testator. And so all the people that owe the testator, it is the duty of the executor to call on them to come and pay their debts. And so as the executor, it was the duty of Mr. Bird to collect from every person who owed his stepmother the monies that were owed. And if anybody was not paying their debts, then in his position as an executor, the executor is entitled to sue that person to come and pay the debt that is owed to the estate of the deceased testator. Now, equity is saying that if you appoint someone who owes you as your executor, you are asking the person to sue your debtors and collect your money for you. But that person also owes you. So it is an anomaly. It does not make sense that that executor, who is also a debtor, will sue himself to collect the money that is owed the estate. And so equity is going to correct this anomaly to say that if we look at the lifestyle of the testator while she was alive, and we can tell that there was a clear intention to gift the property that was owed to the debtor. And even at the time of her death, she showed that clear intention to make that gift. Then the appointment of the debtor as his or her executor will cancel out the debt, such that even though while she was alive, she did not execute a deed of gifts, equity is going to assume that there was an imperfect gift, and then the appointment as an executor or as an administrator is going to perfect that imperfect gift. And that is the rule in Strong and Bird, that if there is a clear intention to gifts during the lifetime of the testator or the intestate, and that intention persisted, continued, even at the time of death, and then the debtor has been appointed as an executor or an administrator, here, the donee of that imperfect gift, equity is going to perfect that gift in his or her favor. And so in strong and bad, the court held that there was an intention to gift that debt that was owed by him to the stepmother. And this gift was perfected by his appointment as an executor. So that is the rule in strong and bad. Okay, there's a hand up. Agbesi. Okay, we'll go to donatio mortis causa. Donatio mortis causa is also one way that equity perfects an imperfect gift. And when it comes to the donatio mortis causa, it is a situation where the person who owns the property makes a gift during his lifetime, but he intends that gift to take effect when he dies. So here, remember that when we were talking about the 4 essentials of a perfect gift, we mentioned that the title to the property must pass to the donee. But when it comes to the donatio mortis causa, it is an imperfect gift because the title has not passed yet. However, there is a clear intention to gift. And the donatio mortis causa is often referred to as a gift in contemplation of death. And so we say that if the person is embarking on a dangerous journey or the person is severely ill and the person contemplates that he or she will die, here again, I think I have to emphasize that it is not made in expectation of death. And so, for instance, someone is going to have brain surgery and he contemplates that he may die, but he does not expect that he will die. It is the gift is not made in expectation of death, but it is made in contemplation of death. Then he delivers the gift, the subject matter. He delivers the subject matter to a donee. So if it is land, he gives the land to the donee. He gives physical possession of the land to the donee. Then he makes it clear that I want to give this property to you, but I am giving you this gift on condition that it should take effect when I die. So that if I do not die, or if I recover from the illness, then the property will still remain vested in me. And so title to the property, for all intents and purposes, will remain in the donor, the owner. And then he will deliver the property to the donee, who will have possession of it. But title will only pass on condition that the donor dies. So if he does not die, at any time during his lifetime, he can even expressly revoke that gift, since it is an imperfect gift and the title to the property has not passed. Or if he recovers from the illness, he can recover the property. So, as I said, it is made in contemplation of death. So let's say he's going to have a brain surgery or something, and then eventually he dies of a different illness. The gift will still be perfected by equity because the condition has been met. Then the position of the law regarding land, and then the donatio mortis causa rule is that the old position, traditionally under common law, land could not be the subject of donatio mortis causa, could not be the subject of donatio mortis causa. However, the law changed in the case of Sen and Headley, SEN versus Headley, HEADLEY. In this case, the courts applied the donatio mortis causa principle to land. And the principle is that three conditions must be met. First, the gift of the land must be made in contemplation of death, as I have explained. Secondly, it must be made on condition that the gift will only become absolute. That is, the title will only pass on the donor's death. Then, whilst he is alive, he must deliver the title deeds or anything that shows that he is giving possession to the property to the donee. And that is how the donatio mortis causa as an imperfect gift is created. And then once the death takes effect, the condition would have been met, and then equity will perfect that imperfect gift, vesting absolute title in the donee. When you look at the past questions, you will notice that one of the questions that they usually ask for theory when it comes to gifts is to ask you to discuss what constitutes a perfect gift in law, and also the circumstances under which the rule in strong and bad will perfect an imperfect gift. Sometimes the question will also ask you to describe the instances under which equity will perfect an imperfect gift. And so, you know the rule in strong and bad, you know donatio mortis causa, you know proprietary estoppel. These are the circumstances under which equity will perfect an imperfect gift. Sometimes you can have a sub-question that asks you to tell us the difference between the donatio mortis causa rule and a will. Because you would have noticed from the discussion that it is similar to a will, because the gift will only take effect upon death of the donor. But there's a difference between the donatio mortis causa and a will. First of all, a will is a testamentary act. That means that a will takes effect upon death, and then it contains the wishes of the testator, which is take effect upon death, blah, blah, blah. But the donatio mortis causa is not a testamentary act. We say that the property is delivered to the donee during the lifetime of the testator. Sorry, during the lifetime of the donor. And then it is made effective conditionally. From the date of delivery, it is made effective conditionally on the death of the donor. And then another thing is that when it comes to the revocation of the gifts under donatio mortis causa, it can be expressed or implied. During his lifetime, after he has told you that in contemplation of death, he is giving this property to you and that he has every intention to gift it, he can even come back at any time to revoke it expressly. Or when he recovers from the surgery or that illness or that dangerous journey that he was embarking on, he can come back and then assume absolute control over his property. Impliedly, the donatio mortis causa would have been revoked. And so the imperfect gift cannot be perfected here. Or if he takes back the property that he has delivered to you, In any of these instances, there is revocation of the gift under the donatio mortis causa. But when it comes to a will, once a will has been made, you have to either do a codicil or another will to revoke it. And that is one difference between a will and then the donatio mortis causa as a gift. Another thing is that, remember when we were talking about vesting assent, I noted that when someone makes a will and then gives property under the will to a beneficiary, when the testator dies, the executors of the estate must execute a vesting assent before the property will become vested in the beneficiary. But when it comes to the donatio mortis causa, you don't need a vesting assent to perfect the title of the donee. The property is already with him as an imperfect gift. Immediately upon death, equity will perfect that imperfect gift, and you don't need to execute a vesting assent. So these are some of the differences between the donatio mortis causa and then the will. Yeah, Abna. Okay.
You made a point that there are rules in strong and bad that's needed for. You may be asked the question how to perfect an imperfect gift under strong and bad.
Yes.
So did you list any elements under strong and bad?
Yes. So I'll go over it.
All right, thank you.
So under the ruling strong and bad, there are 4 conditions. First, the donor, the owner of the property, he must show a clear intention to make a gift during his lifetime. During his lifetime, there must be that intention. So he must have intended to gift the property during his lifetime. Secondly, that intention to gift must persist even until his death. So at the time of death, that donative intention, as we call it, the intention to gift, must be there at the time of death. The third point is that the donee of that imperfect gift must be appointed as the executor or the administrator of the estate of the donor. Then, lastly, the property that is being gifted is also important. It must be one that is capable of enduring. It must be capable of enduring the donor's death, such that after the death of the donor, it must be that kind of property that you can say that the donee can take. And so, if you are asked a question, discuss what constitutes a perfect gift in law and the circumstances under which the rule in strong and bad where equity will perfect an imperfect gift. These are the things you must mention. And then you can even add the fact that the once the rule in strong and bad applies, any claim that a beneficiary under the will or under intestacy would be entitled to in respect of that particular property will not take effect. The once the rule in strong and bad applies, it will override any claim that a beneficiary under the will or intestacy may have. And then I'll clarify that a bit. So, for instance, in strong and bad, if under the stepmother's will, there is someone to whom the testator described as his or her residuary legatee, such that any money that is due to me, I give to maybe Kofi. When Kofi decides to take monies due to the testator, it will include monies that are owed to the testator by his or her debtors. Here, the executor of the will, who is also one of the debtors, will not be required to pay the money to Kofi, even though Kofi is a beneficiary under the will. And the simple reason is that by virtue of his or her appointment, equity has already perfected that imperfect gift, and it no longer forms part of the estate of the testator, which is to be distributed. So, Abner, I hope that answers your question.
Yes, I'm saying. Thank you.
Yeah. So it's about 15 minutes past 12. I wanted us to go through the checklist for drafting a gift briefly, but I think the deed of gift is one of the simple instruments to draft, and the distinctive element when it comes to drafting a gift. So at this point, I assume that everybody knows the commencement date parties. Your parties are the donor and the donee. You begin by establishing the title of the donor. The donor has the property. So you have to be able to tell us that he has the property. How did he acquire the property? So for instance, you say that by a lease or by a conveyance, in whatever way that the donor acquired the property, you must trace that root of title as your first paragraph in the narrative recitals. You must state it. So maybe by lease dated this day or that day, the donor acquired the property from X to forever. That's if it is a conveyance. If it is a lease, by lease dated this, the donor acquired the property from X2 for a period of 90 years. Then you state it. Then in your next paragraph, you emphasize the fact that the donor is the beneficial owner of the land. Then you go ahead in your next paragraph to tell us the relationship between the donor and the donee. And you'll notice that in the past questions, whenever there is a question on gifts, it's either from husband to wife, wife to husband, parent to child. And so you bring a clause like that, that the donee is the wife of the donor, or that the donee is the son of the donor. You bring that clause. Then you move on to your introductory recital. And then the introductory recital could either be one or two. So basically, it is that part of your drafting where you tell us the decision of the donor to gift. So a simple statement that the donor has decided to make a gift of the property to the donee will suffice. But sometimes maybe the question will add some facts. So for instance, there is this question for those on the main campus. There is this question that Mr. Sevo uses for tutorials, Cynthia Wells. So you notice in Cynthia Wells that her son had graduated first class honors in psychology from the University of Ghana. And she was so proud of him that she wanted to give him a land. And so here you can say that the donor has decided to make a gift of the property to the donee in in appreciation of the donee having graduated top of his class. Something simple. There are some people who would even say that all of those things are not needed. Just establish the fact that the donor has made a decision to gift. To them, that is the introductory recital that they must see. Then you move on to your operative part. In your operative part, again, as I indicated here, because it is a gift, valuable consideration is not given. That is, the donee does not pay money. If you were to draft a lease or a conveyance, if it was a conveyance, you'd have said in consideration of the sum of maybe 1 million Ghana cedis, receipt of which, in consideration of the sum of 1 million Ghana cedis paid by the how do you call it? The buyer to the vendor, receipt of which the vendor hereby acknowledges. Those things, that's consideration, receipt and consideration clause. You will not see the exact same thing when it comes to a gift, because a gift is a voluntary transfer of property. And so when it comes to the operative part of a gift, you say that it is a standard clause that you must familiarize yourself with. And it says, in consideration of natural love and affection. That is it. That's the consideration. In consideration of natural love and affection, the donor, as beneficial owner of the property, hereby conveys, the words of conveyance must come, hereby conveys the property to the donee as a gift forever. And so in your operative part, first, the consideration, natural love and affection. Secondly, the covenant for title, the donor as beneficial owner. Thirdly, your words of conveyance hereby conveys to the donee. Then your parcel, you must describe the property, the property in the schedule to the donee. Then the duration, for how long? Forever. It is a gift. That is your operative part. Then, if there are any third-party rights, such as easements, you bring them in your next clause. Then you move on to the donor's covenants. The donor's covenants are two main things. One, the donor is telling the donee that he is giving the donee good title. So he covenants that the donee has good title. Secondly, the donor covenants that the donee will peacefully and quietly enjoy the property that is given to him or her. And then that brings you to the end of a gift. You bring your testimonium, schedule, and then attestation. It must be attested to by at least one witness. It must be attested to by at least one witness. Then your oath of proof and certificate of proof. Another thing that I think I must mention is that in some of the questions, you will notice that the donee, the donor require the donee to do certain things. For instance, to keep the garden, to keep the flowers, to do this and all of that. And then there are some people who in their drafting will add these as covenants on the part of the donee. But personally, I do not do that, because when it comes to gifts, the only person who is making a covenant is the donor, and he makes only two covenants. First, that the donee is receiving good title. Secondly, that the donee will enjoy the property quietly and peacefully. The point of covenants in an instrument is that they create liabilities. They create is a contract. So if the other person fails to perform, you can sue him or her on it. But the nature of a gift is that once you gift property, voluntarily, you've given your property away. It will not come back to you. And the donee chooses to do with it whatever he or she wishes. you can't do anything about it. And so if he decides not to keep the garden or do all those things that you mentioned, there's nothing you can do to him. You cannot, the gift has already passed, the title has passed. Once the gift, the deed of gift has gone to the lands commission, you've registered it and everything. That is it. And so I don't see the need to bring any covenant on the part of the donee. So that's for the drafting of a gift. But the other thing that you must note is that sometimes you can have a gift under customary law, and the question can include that. So the main thing that distinguishes what we've done in a customary gift is that in a customary gift, there is an element called aseda or thanksgiving. So under customary law, remember when we were looking at the elements of a gift, we said that somebody owns property, a person has an intention, shows an intention to gift, and so gives the property to the donee, and then the donee accepts it. Under customary law, the acceptance of the donee must be evidenced by what we call the aseda, and this is usually done by customary gifts. And so when you have a question that has aseda in it, you have to include it in your drafting. And the aseda or the customary gifts, the customary drinks, always come immediately after the operative part. Immediately after the operative part. And so I want to read a question for you. So there is a question here. Benjamin Into has a house with plots number 18, Block C, Spintex Road. He has decided to donate the plots and the building on it to his wife, Mrs. Esther Into, to reciprocate her love for him. Benjamin is illiterate but rich. When Benjamin's business collapsed, he went for a loan for her. Mrs. Into went for a loan for her husband to revamp his business. She maintained the house for 3 years during the period that her husband's business failed. Benjamin has come to you to prepare a deed of gifts for Mrs. Esther Into. Prepare a deed of gifts from Benjamin Into to Mrs. Into, indicating the customary drink of 10,000 cedis given by the donee to the donor as an acknowledgement of the customary gift of plot number 18, Block C, Spintex Road, in the presence of some family members and friends. And so when you have a question like this, you begin your narrative recitals, the root of title, how Mr. Into acquired the property. That is the beneficial owner of the property at Spintex. That's the donee is the wife of the donor. That's the donor has decided to give the property to the donee in appreciation of her support during times when he faced difficulties in business. In consideration of natural love and affection, the donor as beneficial owner of the property hereby conveys the property to the donee as gifts forever. After you do this operative part, it is then that you bring your aseda, the customary gifts. So here in the question says that Mrs. Into draft the deed of gift, indicating that from a deed of gift from Mr. Into to Mrs. Into, indicating the customary drink of 10,000 cedis given by the donee to the donor as acknowledgements of the gifts in the presence of some family members and friends. And so when you have a question like this, right after your operative part, you must bring a clause that talks about the aseda or the customary gifts. And so in this clause, you say, in acknowledgement of the gift made to her, the donee has paid to the donor a customary drink of 10,000 Ghana cedis, so in words and then figures, receipt of which the donor acknowledged in the presence of some family members and friends. So that is the aseda, or the customary drink, or which makes a customary gift different from the regular gifts, and that's the only difference. Every other thing is the same. So we are about 30 minutes past time, so I think I'll end here. It's 12:28. If there are any questions, we'll answer them in 2 minutes, and by 12:30 we'll be out of here. Okay, so in the absence of any question, I think we can bring our session to an end. Thanks to everyone who joined this session, and I hope we will meet next week. Thank you all. Have a good afternoon.
Thank you.
Thank you too.
Thank you
You're
too.
welcome.
Thank you very much. We are grateful.
Very well done. Very well done.